language that is not your, if it's a second language, because when I was in law school in the United States in English, and I grew up speaking English, obviously, it's still sometimes the reasons and the decisions rely on, very fine distinctions in the language. And it requires you to think very critically, and how, the meaning is sometimes an interpretation of a contract depends on the meaning of one word and how many different things that word might mean in English. I don't know so much about Ukrainian, but sometimes in English we have words that it might mean 2 or 3 different things. And so then you argue about which meaning of the word is it. So that can be a little bit difficult in a second language. So, but I'm going to try to work with y'all to get y'all thinking and trained the way American lawyers are trained. So you'll be all ready to work with American lawyers as soon as you get out of law school. But anyway, so to go back and pick up some ideas from the last class. Did anybody remember what was the case that we talked about in the last class? You remember the name of it?
Not really. Can you say it again?
Yeah. You remember the case of Fletcher versus Peck?
Oh, yes.
Remember what that was about? Maybe nobody had any idea what it was about.
About land of zone.
I'm sorry?
Land of your zone.
Yeah, it was about sale of land. And I can't see all of y'all on there. So when you speak for now, maybe we'll get to where it's better. Before you speak, can you say what your name is so I know who's talking? Which is, by the way, what you have to do in court. And if you're going to learn to be a lawyer and not practice in a court in the United States, the first thing you do is get up and tell the judge who you are, your name. I am, let me see, I am Tatiana Ruslavivna Trishik, and I represent da 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 da. And then you go on. So we're going to do that in this class because 94 students, I got to try to learn who is who. So if you don't mind, before you speak, act like you're talking to the judge and say your name so everybody knows who's speaking. Do y'all all know each other? Do any of y'all know each other already from other classes? Maybe y'all don't know each other. So anyway, I need to learn who you are. So partly so I can give you a grade at the end of the class. And maybe it'll help for y'all to learn who each other are, because part of the point of a law school class, at least in the United States, is a lot of discussion. And you might not agree with the case. So remember we talked about Fletcher versus Peck last time, and that was the case in the early history of the United States, 3 years after the Constitution of the United States was adopted. And in the state where I went to law school in Georgia, I went to law school at the University of Georgia, which is for your geography. So I teach now at the University of Alabama, which is right next door to Georgia, and they're both in the South. And that's why my friends from the United Kingdom said they can't understand me because we have an accent, a Southern accent in the South. But in Fletcher versus Peck, the early history of the state, the legislature was bribed. It was total corruption. They were bribed to sell all these lands that are now the state of Alabama and the state of Mississippi. They were bribed to sell it for almost nothing, for about a penny and a half an acre. They sold 35 million acres, which is maybe 200,000 hectares or something like that, for a penny. So a penny in the United States is maybe, let me see, 40, it's maybe 2 grivna. So imagine if you bought a hectare of land for 2 grivna, and of course the legislators, the what y'all call the RADA members of the state of Georgia were bribed to sell this land to a company for 2 grivna a hectare, which of course has a ridiculously low price. And then all of those people were voted out of office. They got a new legislature, a new RADA, new people in it, and they voted to rescind that sale that was corrupt and illegal. And that went all the way to the U.S. Supreme Court, because in the meantime, the parcels of that land had been sold, and so Fletcher bought a parcel of land. I think he bought 13,000 acres for $3,000. Of course, the 13,000 acres that he bought for $3,000 would be worth probably $30 million today. But he was complaining that there was a broken promise in the deed, because the deed, the contract that conveyed the land when he bought it, said that that the seller had good title to the land. It wasn't affected by this legislation that had repealed the sale of the land. It went all the way to the U.S. Supreme Court, and the U.S. Supreme Court in 1810, 15 years after the original corruption, said, well, forget about all the corruption. A contract is good. And does anybody remember the main reason that the U.S. Supreme Court said we have to recognize all these contracts? After the original corrupt sale of the land, people had sold parts of the land to other people. Does anybody remember why the U.S. Supreme Court what was their main reason for saying we can't overturn all those contracts? The state of Georgia cannot pass any legislation that undoes all of those contracts for sale of land. Anybody remember why?
To be honest, no.
Okay, well, that's honest. Okay, well, that gives me an idea where we are. So, okay, your professor is going to have to help y'all along here, because you're not going to be learning much American law if you don't understand these cases. And it's not easy to understand, especially that one that was written in 1810, because they talk and write in a way actually is hard for us to understand today. But the history is important. As we will see in these other cases, the history of the development of the law is important. Anyway, the reason the U.S. Supreme Court said we can't overturn all these contracts for selling this land, despite the corruption, despite the bribery, because the people who later bought land from the corrupt people, they were innocent purchasers. They didn't know about the corruption. They didn't know about the legislation the next year that had repealed the whole original sale of the land. And so if people pay good money, it's called a bona fide purchase, which is a Latin term, bona fide purchaser without notice. People who were innocent and paid their money, and they didn't know about the corruption, that you couldn't overturn all of those land sales. Somebody tell me, if you were the lawyer trying to argue against the Supreme Court's decision, how would you argue against that? And they said, we can't. There were probably hundreds, or the original sale was for 35 million acres. And so then the corrupt people who bribed the RADA and bought the 35 million acres, they started selling it to other people. So, for instance, the plaintiff in the case, John Fletcher, bought 13,000 of those acres. And Supreme Court said can't overturn that despite the corruption, because all these people who bought these smaller parcels of land were innocent purchasers who didn't know about the corruption. They weren't involved in the corruption, didn't know anything about it, and paid their money. So we shouldn't overturn those contracts. If you were a lawyer on the other side and you're trying to argue against the U.S. Supreme Court decision, what would you say? We got 94 students. We got one who can come up with an idea of how you would argue to the Supreme Court. That's not right. You can't say that
Maybe
these
we could say,
contracts all have to be
we
good.
got the papers, we got a deal.
I'm sorry. Who is talking? Tell me your name and then say, give me your argument. Somebody just said something and now they're getting shy. Okay, well, I'll tell you, if I were the lawyer and I was arguing with the Supreme Court justices, trying to say that's not right. And understand this is important, because in the United States, it's a common law system where everything is based on the prior decisions, and what those decisions mean depend on the facts of the cases. So the Supreme Court said we had this original corruption where people bribed the legislature to buy 35 million acres, and then they sold it to other people. And the Supreme Court said we can't overturn, the state of Georgia could not overturn all those sales that originated in corruption, because those later people, they didn't know, they were innocent, and they paid money. They didn't know about the corruption. They didn't know about the repeal. And y'all understand, might need to get more basic with the language. Y'all understand what a repeal is?
No.
No. Can you
Okay.
explain?
All right. Well, and that's okay. Well, we're making progress. So when I'm talking, if you don't understand what I'm talking about, if you're a good lawyer, you're going to speak up and say, Professor, stop. I don't understand what you're talking about. So in 1795, the Georgia legislature, the Georgia RADA, passed this bill saying we're going to sell 35 million acres to this company. And understand that was the corrupt sale. The RADA had been bribed to sell that land at a ridiculously low price. So the next year, the legislature, the RADA, came back with different people and said that was crap, and we're repealing that, which means, so in 1795, the RADA passed one law saying we're selling all this land, and then the next year they came back and repealed that act, which means they nullified it. They said that act is no good. The one the RADA passed last year is no good. There was no sale. We're taking it all back. Y'all understand? Does that help?
Yeah, I get it, bro.
Okay, all right, good. I don't want to over-explain it. So anyway, so that's what the U.S. Supreme Court said, that the Georgia RADA could not come back the next year and overturn the original contract because all these innocent people had later on bought parts of that land. So you're the lawyer on the other side, and you want to argue with the Supreme Court, so you can't decide that. And how would you argue? First of all, think of what is it the Supreme Court decided? What was the basis of their decision? That all those people, those thousands of people, they didn't know anything about the corruption. How would you argue the other side of that? And think about the facts of the case. Do you remember? If you were trying to argue that those people were not innocent, that they probably did know about the corruption when they bought the land, what would you argue? Okay, well, we're going to work
About who was innocent.
I'm sorry?
We're trying to find who was innocent in this case.
Yeah, well,
From the
if you were
governor,
trying to
I
argue
don't know.
that all of, so, well, here's what the Supreme Court did. They say in their decision, all of them were innocent. If 1,000 people later bought a piece of that land, they were all innocent. They knew nothing about the corruption. And if you were the lawyer on the other side trying to get them to decide something different, what would you stand up and say to the Supreme Court justices? Think about the facts of the case, remember?
It's also corrupted.
Well, there was corruption. And how would you argue that the people knew about it? That
I think they knew but can stop because that's like a closest circle, because that start in like a just people, I don't know how to say, that's a poverty when you know, like when people have not a lot of money in some job, so some good people take them more, they clients, like I don't know how to say, maybe some doctor in some country have a really not a lot of money. So some people take their money and they have more. And that makes like a habit. So that starts in some down. So
yeah,
I think
well, you're saying that some people have more power and influence than other people.
yeah.
So, and well, and that's part of it. And I would say that the US Supreme Court made, you know, a very political decision. And I'm not sure that they were doing it to, well, in a way they were doing it to try to support more powerful people. But one thing that they were doing, and what this case has come to mean, and that's why it's important in US law to understand the history. One thing that's important to understand about this case, Fletcher versus Peck, is that so long ago that really people have forgotten most of the facts of the cases. And so in the history of American law, it's come to stand for the principle that, you know, that you cannot overturn a contract. We're not going to, and really it's going to, you know, it's not going to be a country where a legal authorized agreement, the government can just come in later and say that was no good, because that's, when you talk about that, you're talking about a country like, you know, Putin, where, oh, this was the rule one day, but I'm Vladimir Putin, so I can change the rule the next day if I want to. And so it was really a decision that the United States was not going to be that kind of country. and especially was not going to be that kind of country in relation to business and commerce. And it was really a decision. What it's come to mean in history was that in business, you could rely on a contract and you could rely on the law that existed at the time, and that no oligarch can come along and just say, we're just going to change the rules on you. Because is that a good way? Is that good for business? Well, it might be good for business if you're the one changing the rules to benefit yourself. But it was really a decision that legal transactions and sale of property and business and commerce were going to be stable and follow rules that could just not be changed the next year. And that was really the purpose of the decision. And you could probably say after history that was a good decision. You could also argue that the facts of the case don't really support it. And remember, trying to help y'all understand the American and English system of law, which is common law. And that, can somebody explain to me what that means? Does anybody understand what that means? What's a common law system? Well, what it means is that that the law develops through court decisions, and that they have, I'm sorry?
They have precedents.
Yes, that's exactly right. That's so a prior decision has precedence, and one thing that means is that the facts of the case are very important, because if you're a lawyer in the United States and the lawyer on the other side brings up a case, they say, I should win this case because Fletcher versus Peck supports my argument. And you're on the other side and say, no, actually Fletcher versus Peck does not support your argument, because Fletcher versus Peck is based on very specific facts, which are different from this case. So to be an American lawyer, you have to look at these cases. And I gave y'all some cases to read for today, and y'all, I don't know, y'all might not have understood them at all, but I'm going to try to. I'm sorry?
Mr. Stephen, we have to read it because a lot of students here don't understand the federal system, the court system of the US. So this might be the problem. We need to read cases.
That's a very good point. And I can't say, tell me your name. Who's talking?
Volodymyr.
And what's your family name? Because I probably got 10 Volodymyrs in here. Anyway, those are good points. And this is a contract law course. And so I'm trying to walk y'all through a little bit what American students study in contract. But Volodymyr makes a very good point of you have to understand the court system. There are a lot of things you have to understand that are not necessarily contract law. You have to understand the court system, the different kinds of courts. You have to understand some of the procedures, which some of these cases that y'all read for today talk about various kinds of procedures, which y'all probably did not understand. And so I'm going to try to explain to y'all. So to understand and practice contract law, you have to understand a lot of other things about American law. So we're going to, try to talk about some of those. But anyway, I'll be the lawyer. So I asked you the question, like if you're in Fletcher versus Peck, you're the lawyer on the other side, and the court has just said, we can't overturn all these contracts, these later contracts after the original corrupt sale, because the people didn't know, they bought the land, they paid the money, they were innocent, they were all innocent, which maybe it's possible that some of them were, but the Supreme Court makes this very sweeping statement that they were all innocent because, again, what the court was really trying to do was to create stability in the economy of the early United States. Because what would happen if they had 1,000 of these contracts and they had to go through and try to sort out, well, which ones were valid because the people were really innocent and which ones were not valid because the people really knew about the corruption or were part of the corruption? It would create all this confusion. And so the court just said, bam, we're going to validate all of these contracts. If I were going to try to argue my client's case on the other side, and that's another important point that came up in Fletcher versus Peck. In this common law system that the English and Americans use, the only issues that the court will consider are the issues that are raised by the attorneys. So there could be like a huge issue out there. If the attorneys don't raise it, the courts don't consider it. And that might seem strange in other countries. But so does anybody remember what was a huge issue that that the court didn't really decide because the lawyers, didn't bring it up? And that was the fact that a lot of these lands that were being disputed in this case were actually also claimed by American Indians or Native Americans, we call them now. That was a huge issue. So they had sold a lot of land that belonged by treaty with the United States to these Indian nations, the Creeks and the Cherokees and the Choctaws. And what's a treaty? As a contract law class, a treaty is a contract, is an agreement between two countries. And the United States had agreements with these Indian tribes that they owned these lands, and yet Georgia sold the same land. But that was an issue that the court didn't really address. Was somebody trying to say something? I'm sorry.
It doesn't matter. Go on.
Yeah. Okay. It doesn't matter. All right. So anyway, if you were going to argue the other side, you would say, if there were 1,000 of these sales, 1,000 people had bought 100 acres or 500 acres or 1,000 acres, or like Fletcher in this case, he bought 13,000 acres. If you're going to argue the other side, you'd say, there is no freaking way that none of those 1,000 people knew about the corruption, knew about the repeal of the legislation by which that land was sold. Because remember what happened. First of all, the legislature, the RADA, came back the next year and repealed the act and said, we're canceling that contract. So that's a public act. Do you think nobody knew about that? So, and do you remember how they repealed the act that was very dramatic and called a lot of attention to the repeal? Does anybody remember? How did they repeal the act? Did they just write some words down and say, we repeal this act? What else did they do? It shows some of the flair and drama in American history. They were so mad about the corruption, about the RADA members who had been bribed, they'd been paid by the people who bought the land to sell it to them at a very low price. And people were so mad when they found out that not only did they pass an act the next year saying, we repeal that act, we cancel the contract, cancel that land sale, they actually took the legislation, the contract by which all the land had been corruptly sold, and they burned it in public. Remember, they set up a big magnifying glass and they concentrated the sun's beams and set the contract on fire. So if you were the lawyer on the other side trying to argue, yeah, some people must have known about the corruption because they repealed the corrupt act and they had a giant public ceremony. Well, and the whole state of Georgia was up in arms. People were mad about it. They had a public burning of the legislation. So anyway, those are things you would argue on the other side to say, if the lawyer on the other side said, nobody knew about the corruption. Any of these people who bought the land later, none of them knew anything about it. And you're the lawyer on the other side said, sure, they knew something about it. They repealed the sale in the legislature, in the RADA, and they took the bill they were repealing out into the public square and set it on fire. And obviously that called attention to it. And you think like nobody knew? It was, in the newspapers all over the country, everybody knew about it. So anyway, that's a strange way that common law works. It's determined by the facts of the cases. And so you need to be very careful about what the facts of the cases are. And also, I'll give you a hint they didn't give us in American law school. Don't really be necessarily fooled by the reasoning of the judges, because sometimes it's very illogical. But and I would argue that this Fletcher versus Peck, the reasoning is not very logical, but the principle was accepted in America, and people kind of forgot about the facts of the case, that it was based on this idea, which is not, first of all, they overlooked the corruption, which you could argue like that's just plain wrong, that something should have been done about the corruption. Somebody should have been accountable for the corruption. There should have been some consequence for the corruption. And you'd also could argue that there's no way that everybody who bought pieces of that land were innocent and didn't know anything about it. But in American history, everybody's forgotten about all that. And the case just stands for this principle that it's a country in which contracts are going to be honored, and the government. So, there's a, bad way of looking at it, like, well, they ignored the corruption. That's terrible. The good way of looking at it is, well, we're going to have stable commerce, and we're not going to allow the government to come in, after a deal is made 1 year. And, of course, this is what it would happen. Vladimir Putin, he could come back the next year and say, that deal was no good. What the government did last year is no good. I don't like it. Doesn't benefit me anymore. So I'm going to change it. And so that was really what the U.S. Supreme Court was trying to do. And also to support this idea that, getting back to contract law, that it's really a kind of private law that's not created by the government, but is created by the people in commerce bargaining with each other. And so it creates a freedom of commerce that coincides with the personal liberty and freedom and of a democratic government. So it's, people in the market expressing their free will, as opposed to the way economies had always worked before, where the king, said what was going to happen, or, in the Soviet Union, where they said, this is what we're going to do in our 5-year plan. And so, but we saw in Fletcher versus Peck that even though the idea of contract law is that people are free to make whatever agreements they want to, that it's really the government backing that makes it all enforceable. So, for example, there was a case that was related to the American Civil Rights Movement in 1948, and this is over almost 200 years after the Constitution. And I teach another class, which is on the civil rights movement. Y'all might, know something about it, Martin Luther King, and Black people in America didn't have any rights, and people in the United States until 1948, when they transferred property through a contract and through a deed and a change of a title, lots of Americans would put in the contracts to sell houses and property that the deed would say, I'm going to sell you this property. They'd sell it to another white person, and they'd put in the contract, but you can never sell this property to a Black person. And I'm sorry?
That's racism.
Yeah, it's racist. It was racism. You're correct. But you see how that's a problem in the idea of contract, whereas, private parties can do whatever they want. They can make whatever agreements they want to. And yeah, that was racism. And it also should have been against the law in the United States, because we had passed something called the 14th Amendment in 1868 that said that the state could not discriminate on the basis of race. Yet all these deeds for sale of land and property were containing these what were called restrictive covenants that said this land can never be sold to a Black person. And that went to the U.S. Supreme Court in 1948 in a case called Shelley versus Kramer. And this gets to something we talked about last time. You said, "Oh, Professor, you're telling us all this theory, and we want to learn, practical stuff about business." However, you need to understand that the theory controls what's possible in the law and in business. So this was business that was happening in the United States. People were selling their property, said, I'll sell you the property, but this property can never be sold to a Black person, because they didn't want Black people moving into their neighborhoods. And so when that case went to the U.S. Supreme Court, the Supreme Court had a decision to make, because the whole idea of the United States was you have freedom of contract. You're free to make whatever kind of contract you want to. And under that principle, people were free to write a contract and say, I'll sell you this house. You can buy my house, but I'm going to put a deed in here that will run to everybody who buys this house, from now on, that this house can never be sold to a Black person. And so when the Supreme Court looked at that in 1948 in a case called Shelley versus Kramer, they said they did not want to go against the principle of freedom of contract. So they decided, yes, people are free to put whatever they want to in a contract. You can put, I'll never sell this to a Black person or a green person or a purple person. But the way the Supreme Court stopped that, it was saying, and again, this goes back to Fletcher versus Peck. We're thinking about contracts are free in our society. You can write a contract, make whatever kind of deal you want to with somebody, put whatever you want. I'm
Can
sorry.
you repeat this, the name of this pack?
The name of
Pack.
what?
Oh, I will tell you later. Maybe you will talk about it.
Okay. Yeah, I couldn't understand you asked me to repeat the name of something, but here's a case called Shelley versus Kramer. And the Supreme Court said, yes, people can write whatever they want to into their contracts, but, and this relates to the idea of Fletcher versus Peck, that even though you have freedom of contract between individuals, it's still really the government that's backing everything up. Because why? If you want to enforce your contract, where do you go? You think somebody's broken a promise in their contract, they haven't fulfilled the contract, what do you do to try to make them follow the contract?
You go to the court.
You go to the court. And is the court a private party? No, the court's the government. So it's really all this private enterprise has to be backed by the government, and that's the theory. So in Shelley versus Kramer, they said, yeah, you can write whatever you want to in your contract. They didn't say you cannot put a clause in your contract to say that this land will never be sold to a black person. This house will never be sold to a black person. People can write that in their contract if they want to. They're free to do it, but the government will not enforce it. And so you can write it in your contract, but you can't go to court and enforce it. So that's how, and the idea is that the courts are always trying to decide these cases, even though they're very practical business cases, according to the theory that's laid down in the law. Why? Because common law depends on precedent. And so the courts are always trying to reconcile all the past history of the cases with the new problems that are coming up in the law. And you need to understand that that's the way the American system works if you want to work with American lawyers. Another point from the elision, remember, continuing from Fletcher versus Peck, if you remember there was a note on the first page talking about the attitude of the court. And when I first came to the State Tax University in Irpin and talked to the acting rector, Valentin, at the time, and first raised the idea of like, maybe I could help teach some classes here. I said I could teach French. So maybe next semester I could be your French professor, but there was a term in the paper you read about laissez-faire, which is a French term. Does anybody, I'm trying to get y'all to understand English, but does anybody understand what that French term means? Laissez-faire. It's a French term that's used in English, and it literally means to let people do what they want. And so Fletcher versus Peck in some part was a laissez-faire decision. The court saying, let people do the contracts they want to do. The government's not going to interfere in it. In later American history, that term laissez-faire became very important because actually the government tried to come in and the US Congress and pass laws, for example, protecting workers. Giant monopoly companies had developed in the United States, run by what we called robber barons. Y'all call them oligarchs. And these companies were so big and so powerful, they could really do anything they wanted to, and they could hire people under any kind of working conditions. And so in like, we're talking about the period of like the 1880s and the 1890s in the United States, it was a big problem and almost a revolution because the big companies had all the economic power, and they could make workers and when you go to work for an employer, what's that? That's a contract. That's an employment contract, an agreement to work for somebody. If you go, become a, lawyer for a law firm somewhere when you graduate, you're going to be working under an employment contract of, your terms of your employment and how much you make and how much you have to work. And, but in the days of the 1880s and 1890s, the employment contracts were terrible in the United States. These big industries would have people working for almost no money, and they could make them work 7 days a week and 12 hours a day. And sometimes they would not even pay the workers in real money. They would pay them in this paper that the company issued, and the company had its own store. So you had to take your paper and, to the company store to buy things. So you were, it was really almost a feudal system. And the US Congress tried to come in and pass some laws and say, a big company, a big monopoly oligarch cannot, make people work like serfs, and can't make them work 14 hours a day, every day, and, make 10-year-old children work and all that kind of thing. They tried to pass laws limiting the hours that people could be made to work. And in that era, the court came in a laissez-faire, what was called a laissez-faire philosophy, and said that the Congress could not interfere in those contracts and improve working conditions. And that was called a laissez-faire attitude of the court. The point of all of this history is that existed during a certain period of time, and later the court changed its attitudes and said, yeah, the Congress can, we don't agree with this laissez-faire philosophy anymore. And Congress, the US Congress does have the power to come in and create better working conditions and say, you can't make people work for nothing and make them work for 14 hours a day and all that kind of thing. So the thing to understand is that the courts change over time for lots of reasons, for the philosophy and the politics and the policy and everything else. And so you have to understand how the court system and how the court philosophy is changing if you want to be, a good lawyer in America and understanding the American legal system. And we y'all are good students. One thing we always try to do is like get the teacher talking about something else, and we don't have to be questioned on these cases. So we're a little bit behind because we're about used up all our time, but I think it's valuable because if people were not understanding some of this stuff on a basic level, try to get y'all understanding basics before we get into more complicated. So we'll go into these cases some more in detail next week. But I think now maybe you'll have a better understanding that you really need to pay very close attention to these facts in the cases and pay very close attention to the reasoning that the courts use to decide the cases, and think about whether you agree with it. And if you were the lawyer trying to argue against that decision, how would you argue that decision is wrong? Because because of the facts that the court relied on, or because of the rule of law it relied on, or how that applies to the facts of the case, because that's how the common law system works. And we just have a few minutes left, and I want to spend some time asking y'all what y'all think about, speaking all this stuff about American history and everything. What do you think about Joe Biden coming to Kyiv?
That's great. It was like a huge signal before the win of Ukraine.
It's really
Yeah.
motivate our country, our people.
Yeah, I thought it was fabulous. You know, we have a issue in the United States. I don't know if you're aware of it, but of course we can't claim to have, you know, near the, you know, suffering caused by Russia that y'all have. But Putin has been a very evil man in our country, also spreading disinformation, interfering with our elections, and working very hard to try, for example, to get people elected in our government who will not support Ukraine. And there's a lot of disinformation that comes out of the Kremlin. They spend a lot of money trying to get it into the media in different countries, including in our country. They give a lot of money to politicians who will come out and say, so we had not a majority, but yeah, I thought, to me, it was disturbing that we had some politicians in the United States that criticized Biden for coming to Kyiv to support Ukraine. And they complain and say, oh, we should, you know, take care of ourselves and not, you know, worry about Ukraine. And of course, you know, I believe it's in, you know, our interest to help Ukraine. I think it helps
Mr.
America.
Stephen,
I'm sorry?
Mr. Stephen, I think they approved F-16s to Ukraine.
They what to Ukraine? I'm sorry.
Approved F-16s, jet fighters.
Oh, well, good. Can you fly
I think
one?
I think it was the main case of this discussion with both presidents, but it was not public information.
Yeah. Well, I hope so. And I think it's important to keep the United States support for Ukraine strong. That's why I started coming to Ukraine back in the spring. And so we are about out of time. Anybody have any other questions or comments they want to make? Okay, for next time, see, y'all have done a good job. So we haven't talked about any of these cases, so I'm not going to assign new reading, but here's what I'm going to assign y'all to do. Thinking
Mr.
about
Steven,
everything.
I have some words for you. Hello,
I'm
Mr.
sorry?
Steven.
Yes.
Hello, Mr. Steven. I am Dmitro. I'm Prof.
Oh,
in school
Dimitro,
Dmitro.
how are you doing? I'm glad you.
I am one from your listeners. I am really glad to see you in this time, at this time in the evening. I thank you for your lecture. It was really interesting. As you have heard, on the one hand, our students and our Ukrainians want to have a new knowledge in the law, but on the second hand, all of us need to support Americans in our war with Russia, as you have had some minutes ago. This law is good, but F-16 is better.
Well, that's right. Especially as we discussed in the lecture, Putin doesn't care about the law. And we know that. And thank you so much, Rector Dimitro, for joining us. I didn't know that you were hiding in the back of the class. You know, in a Zoom class, it's different. When I went to law school, we'd have, we might have 200 people in a class, all these rows.
I have sat in the last chair, so you can't see me.
I would always sit on the back row and hope that the professor would not call on me.
Я до кожного студента звертаюся, я вам дякую за те, що ви приєднуєтесь, знаходите час, що ви підтримуєте таку ініціативу. Я сподіваюся від вас так само почути фідбек, наскільки ви хотіли би розширити таку практику. Я знаю, що так само зараз приєднаний до цієї лекції ректор. Я сподіваюся, він так само зараз приєднається з певним вітальним словом до кожного з вас. А ми розраховуємо на вашу підтримку, на вашу ініціативу. Зі свого боку будемо підтримувати вас і шукати так само розширені можливості для вашого вдосконалення, для вашого навчання. Так що я дякую кожному з вас. And Steven, exactly for you. And given a word to our rector, Dmitro Serbiansky.
Дякую, Дмитро Юрійович. Беру естафету у вас. Стівен, Дмитро Юрійович, може ви переведете 2 речення? Стівен, я вибачаюсь, не міг мати можливість взяти участь на початку лекції.
Mr. Steven, Dmitro said that he apologized that he hadn't opportunity to start a lecture with other students.
Мав дуже важливу зустріч з міністром фінансів України по питанням розвитку університету.
He had a meeting with the Minister of Finance of Ukraine.
Well, I understand that that's
Ви робите дуже гарну справу для університету і для наших студентів, за що ми вам дуже щиро вдячні.
We really thank you, Mr. Steven. You make a big. I'm sorry for my English, but you do a lot for progress of our university, for our students, for our university.
І сподіваємося на подальшу плідну співпрацю з вами.
And we're looking forward for the next lecture, for the next meeting, for our cooperate with you.
Студентам дуже дякую. Я підключився десь на хвилині 20-ї лекції. Декілька студентів вже заскрінив, так що я сподіваюся, ми на цьому тижні чи наступному зустрінемося. Дуже приємно, що в нас є такий рівень підготовки окремих студентів. Дякую за таку велику аудиторію, що вам не байдуже послухати такого поважного професора і отримати для себе нові знання і нове розуміння тих процесів в юридичній справі, які досить так активно і змістовно професор Стівен вам доповідав. Тому дуже дякую, що знайшли таку можливість. І напередодні важливих матчів в Лігі Чемпіонів, я думаю, ви зарядитеся позитивною енергією і отримаєте додаткові знання для себе. Дякую.
So, Mr. Steven, let's be in touch and looking forward for the next meeting.
Yeah, thank you. So and I understand that that the rector had very important business to attend to, but I'm glad that he slipped in late and also hid in the back of the class so he would not be called on by the professor. But tell him for next week, be sure to read the cases in case I call on him.
Ну, я сподіваюся, аудиторія ви всі зрозуміли там, а Дмитру Миколаївичу Серебрянському тому вже при зустрічі завтра все перекажемо.
Дякую, Дмитро Юрійович.
And I want to repeat how much I appreciate the kind way that I've been received at the university and by the rector and the whole administration. So, and now that the rector is with us, I want to mention too that I think this is a very historic class because it's the beginning of cooperation. I don't know if all your students understand that I'm an adjunct professor at the University of Alabama, and we are now working on creating a Ukraine studies program at the University of Alabama that never existed before, and is partly to teach our students about Ukraine and also to start cooperation with Ukrainian universities. And so this class that I'm teaching is the first class that's the part of our program at the University of Alabama. So it's historic for us, and I'm so happy that it could be with the State Tax University at Irpin, where I've had so much pleasant company and been so kindly received. And I look forward to much future cooperation. And if everybody understood that,
Yeah, that's a great, truly great moment for both sides.
Yeah.
and I appreciate it. But we're over time, and students never like it when the teacher keeps them after class. So I will look forward to, so for next week, try to reread these cases with everything that I explained to you in mind, and see if we will be able to, you know, discuss what these cases mean, what facts were important, how the court reasoned to come to its decision, and to try to understand a little bit more, not only about U.S. contract law, but about how the U.S. court system works and how it decides cases. And I hope that will be helpful to y'all to understand. And thank you. And thank you, the rector and Dimitri also. And I will look forward to seeing y'all next week.
Okay, see you next week.
All
Всім
right.
дякую.
Bye.
І дякую, що запросили. Thank you for lecture.
Yeah,
And
thank you.
good night.
Good night.
Thank you so much.
Thank you very much.
Bye.
It's interesting.
Thank you for
Дякую
your
всім,
support, my
дякую.
friend.
Thank you for the lecture.
Thank you,
Bye.
Mr. Rin.
Thank you for lecture.
Thank you. Bye.
Have a nice day.
Thank you. Bye. Thank you.